All right, the Committee on General Laws and Technology will now meet. Clerk, could you call the roll for the committee?
Senator Ruff. Senator Locke. Senator Vogel. Senator Eben. Senator Reeves. Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi. Senator Kiggins.
Here.
Senator Barker.
Here.
Mr. Chair, you have a quorum.
All right, and we may be joined today by Senator Reeves and Senator Vogel virtually joined since they're not here in Richmond. So they may be joining us to participate here. There are 11 bills on the docket. Well, here's just to give you a quick run through of things. We will take up the two eviction bills that we did not complete dealing with last week when we met. We will not be taking any additional testimony on those bills. We did have about 40 minutes of testimony that went on last week. We then will take up 5 bills together in a block that are similar. These are 5 bills that deal with the state of emergency and involvement of the legislature, et cetera, as it relates to to the state of emergency. I will have each of the 5 patrons of those bills explain each of their bills. Are not identical, but they are similar in certain respects. And then we will take testimony on all 5 of those, and then we will consider action to be taken on each of those, either collectively or individually. And then there are 4 other bills that we will handle individually after that. So even though it's 11 bills, it should not be an extraordinarily long meeting today, and we should be able to get through the docket in reasonable time. I will start by calling back up Senate Bill 5051, which was, the patron is Senator Hashmi. We did have extensive discussion of that last week before we deferred action on it to this week. So I'll call her to present anything additional there. We had about 40 minutes of testimony on that bill last week, so we will not be taking additional testimony. And I will explain one other thing as it relates to that bill, is that there's companion type legislation, companion language that is in the introduced budget from the governor and his administration. So that will have bearing upon what action is finally taken regarding Senator Hashmi's bill. So therefore, I will be looking if there is motion to move that bill forward, to have it be re-referred to the Senate Finance and Appropriations Committees, so that hopefully we could, if we're going to actually take some action along that line, we can sync up the language in the budget and the language in Senator Hashmi's bill if we should so choose to do. So with that, I will call on Senator Hashmi to present where things stand and to make any motions relevant to the 5051.
Thank you, Mr. Chair. There is a substitute, and I move that we adopt the substitute.
Second. It's been moved and seconded that the substitute be adopted. All in favor say aye. All opposed, no. The substitute is before us.
Thank you, Mr. Chair. This is a rewrite of the bill that was presented last week, and it takes into consideration many of the issues and concerns that were raised by members of the public and several organizations last week. It is an attempt to, again, provide a moratorium for those individuals that are in crisis, and especially those that are in crisis as a result of the current pandemic. This bill allows the moratorium to extend 60 days after the expiration or the revocation of the state of emergency declared by the governor, and it also enables the landlord to work with the tenant to make sure that the provisions of the eviction moratorium are enacted and that there is application for the rental assistance programs, and that both landlord and tenant have applied for financial assistance that can help with the payment of the tenant's rent. And it also enables a landlord to take action if a tenant has refused to apply for the rental assistance or provide information or documentation that's needed. I also wanted to clarify today that there is a new application process, a new language also for the Rent Mortgage Relief Program, or the RMRP. And this is what I was referencing last week, and I didn't realize that many of our commentators last week did not have access to that information, but hopefully they have it now. The RMRP financial assistance, it will be paying 100% of the current month's mortgage, 100% of past due mortgage from April 1, 2020 to the present. And it also enables either the tenant or the landlord to apply for the assistance and to work together. So with that, that is the new bill, and it's my understanding that Senator McPike has an amendment to introduce as well.
Senator McPike.
Thank you, Mr. Chairman. I appreciate the patrons' work with various stakeholders on the bill. A couple of different lines of feedback to the substitute. One of the organizations that has been working through this pointed out that one of the, I think, gaps in the process is that many people also self-evict when they receive a notice. And so one of the ideas to incorporate is to be able to connect the landlord to the local rent assistance program, so they actually know that they have an individual that is struggling to meet rent for whatever the reason. And so the second item would be that providing a framework to sort of close the loop in the substitute, which is to say, for whatever reason, that if a person does have a means, they may not qualify for the rental assistance program, and therefore would the entity, the landlord, be able to continue with the eviction. So I think there's sort of two ways to include an amendment, Mr. Chairman. And so I believe Council has two line amendments to the substitute that they might be able to provide to the committee and or read.
All right. I've been informed by staff that we need to undo what we did last week in adopting the substitute before we adopt the substitute that we had today. And so we will do that and then get to your two amendments, Senator McPike.
So moved that we revoke that substitute.
So reconsider the vote by which we adopted the substitute last week. Is there a second to that motion?
Mr. Chair.
Okay, if there's no further discussion, then all in favor of reconsidering the vote by which we adopted the substitute last week, say aye. Aye. All opposed, no. Okay, we will now reconsider that vote. All who want to adopt again the substitute that we did last week, say aye. All those opposed, say no. All right, the noes have it, so that substitute is therefore no longer in effect. And then, Senator Hashmi, you want to make the motion again to adopt the substitute for this week?
I move that we adopt the substitute.
All right, we have a motion and a second. No discussion. All in favor say aye. Aye. All opposed, no. All right, that is adopted. Okay, now do we have the two amendments from Senator McPike?
Mr. Chairman?
Yes.
This is Brooks Broad, sorry. Yeah, the way we've prepared what Senator McPike requested was as a substitute, so we need to take back Senator Hashmi's substitute and propose Senator McPike's substitute. There were just a lot of technical changes that needed to get made to fit everything in, so it works better as a substitute than a ton of line amendments.
So what you have is a substitute that would be Senator McPike's substitute, and it includes the aspects that were in Senator Hashmi's substitute, as well as the 2 additional items that are in Senator McPike's. All right, Senator Hashmi, do you want to make a motion to reconsider adoption of the substitute that you proposed?
Mr. Chair, I move that we reconsider the substitute that was just adopted.
All right, is there a
Second.
All right, if there's no discussion, then all in favor of reconsidering, say aye. Aye. All opposed, no. All right, the adoption of the substitute from Senator Hashmi, all in favor, say aye. All opposed, no. All right, the noes have it, so that is now no longer in effect. Okay, then we have Senator McPike's substitute then. Do you want to make that motion, Senator McPike?
Mr. Chairman, I move that we adopt the substitute. And Mr. Chairman, I apologize. I didn't realize it was drafted in the form of a substitute versus line amendment. So I appreciate the parliamentary gymnastics to get there. So
We'll spend most of our day reconsidering, it seems like. But is there a second to Senator McPike's substitute? All right, we have a motion and a second. Any discussion? All in favor, say aye. All opposed, no. All right, the ayes have it. So Senator McPike's substitute is what is now before us, which has what was Senator Hashmi's this week substitute, as well as the 2 additional items that Senator McPike discussed in his presentation recently. Are there any questions of the patron or that anyone has, or any discussion?
Mr. Chairman?
Yes, Senator Evans.
So just to read Senator McPike's substitute, I'm looking online. I see one that says one was offered on 8/27. That's the Hashmi substitute. Is the other one just waiting? We're just waiting for that to come up online, or?
Let's check with.
Oh, it's up there.
It's
It's
there.
now showing up.
Okay. All right.
So, Mr. Chairman,
Yes.
to reinforce, I think, some of the elements that are now included based on the 2 items I added to Senator Hashmi's substitute. Again, to reiterate, there are sort of 2 concepts added, one of which is that the landlord would provide the contact information to the state or local administering rental assistance program. So we help to connect the dot, which isn't occurring today, between the tenant that is struggling to pay rent for whatever reason. So it provides for a framework of eligibility, provides the contact information directly from the landlord to the agency, thereby preventing the condition which is occurring today, which is someone receives an eviction notice, but they don't get through all the paperwork or they don't know who to contact. And so it's really about ensuring that we connect those in need with the resources available. The other provision, which we had feedback, I think, from last week's testimony, was in the condition that happens that someone does in fact have the ability to pay, but they're just not willing to participate with any of the programs, even though they have the means. And so this does provide for a framework where a landlord can still pursue the necessary legal actions for an eviction proceeding. So there's still, I think, a means to address those who may abuse the system versus connecting the resources to those who really need it. And so that is the intent and framework that's now in the substitute before us.
All right, is there any other discussion from the committee? Is there a motion?
Mr. Chairman,
Yes.
so this will have to go to finance, correct, sir?
It clearly logically should, so we can match up the language that's in the budget, which is being revised at this point again, and so that we can have consistency between the bill and the language in the budget.
Thank you, sir. May I speak to the substitute?
Yes.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate all the work that's going into this. This is obviously a noble cause that we all want to make sure that during the middle of a pandemic, we're not kicking people out on the street. There was a great editorial in one of the papers this weekend about, the mental health aspect of stress on the children and the family and how we can't do it, which we all agree. But then it had one line in it and said, but the General Assembly needs to figure out how to do this. All right, well, there's the tough part, Mr. Chairman. This bill, as I read it, the city of Williamsburg has a no more than 3 unrelated people in a house rule. I don't think it's a criminal act, but if my friend was out on the street and needed some help, or living in a dorm at William and Mary that they shut down, hopefully not, and I just said, yeah, come on into our house, we'll take you, and all of a sudden now there are 4 or 5 people living there. As I read this, I'm not sure the landlord could evict them for that violation, yet the landlord would be in violation. I still wonder if you go through a rent relief program that Senator Evan and Senator Bell worked so hard on, and then you default on that, their bill says you could be evicted. I'm not sure whether this bill trumps it. So there are a lot of questions that I think that really still need to be resolved. I appreciate the patron's continued work on this. She's got the right effort in mind. It's just, boy, the devil's in the details. So I'm going to vote to move this to finance, but hope then that with the matching up, there's a lot more comfort to how we're going to go about what every one of us wants to accomplish, but we've got to figure out how to properly do it. So thank you, Mr. Chairman.
So what is your motion?
I will, so with that circular argument, I will move to report the bill and refer it to finance.
All right, we have a motion and a second to report and re-refer to finance. Is there any discussion on that bill, on that motion? All in favor say aye.
Aye.
All opposed, no? All right, we have 1 no, and that is re-referred to finance. All right, next bill we have is Senate Bill.
Mr. Chairman,
Yes.
I think there are actually several no's over here. The clerk might need a moment to catch those votes.
Okay. If you voted no, raise your hand.
I think we have people online as well. If you don't mind if I call the roll.
All right, we can call the roll.
Thank you, sir.
This
Senator
is a
Ruff.
motion to report and re-refer to finance.
Senator Ruff. No. Senator Locke. Senator Vogel.
Aye.
Senator Evan.
Aye.
Senator Reeves.
No.
Senator McPike. Aye. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins. Senator Barker.
Aye.
Nine ayes, 5 nays.
All right, so that motion passes and the bill is reported and re-referred to finance. All right, the next bill is Senate Bill 5089, Senator Locke.
Thank you, Mr. Chairman. Senate Bill 5089, I'd like to explain what the intent of this bill is, and then I have a motion regarding it. The intent of this legislation was to protect those individuals living in hotels and motels during this pandemic. It was to be a temporary fix. This was not something that was going to last forever. And it was to give individuals the same rights enjoyed by all tenants. And it would only last until the 90th day after the current state of emergency expired. It would give people living in hotels and motels access to rent relief funds, which they're not entitled to because they're not really considered to be tenants, as well as a notice and a chance to tell their side of the story before they could be evicted. And it would make it everyone safer by helping to ensure that people have somewhere to be in shelter and maintain hygiene during this pandemic. So generally people would move into hotels and motels because they had no place else to go due to probably some previous problem with an eviction, or because they didn't have the funds for a security deposit. And a landlord would reject an application, so they would move to a budget motel or hotel room and would stay there. But because of this 90-day window, they would not be considered a tenant as such and have the protections of the Landlord-Tenant Act. But there are certainly, many of you have been receiving calls from hotel, motel owners and localities regarding, the local transient occupancy tax and other issues associated with this legislation. And I had Brooks to draft the substitute, which I am not going to introduce at this time. And there's a lot of heavy lifting associated with this legislation that is too much heavy lifting for this special session. So with that, I'm going to respectfully request that this bill be passed by indefinitely at this time, and we will deal with this during the regular session. And that would be my motion.
All right, we have a motion and a second to pass the bill by indefinitely. Is there any discussion? All right. Then that will be up for a vote now. Can the clerk call the roll?
Senator Ruff. Senator Locke.
Aye.
Senator Vogel. Senator Eben. Senator Reeves.
Aye.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins.
Aye.
And Senator Barker. Ayes 13, no 0.
Senator Vogel's aye.
Ayes 14, no 0.
All right, the vote was 14 to 0, and the bill is passed by indefinitely. All right, thank you. The next set of bills we're going to take up are the 5 bills that deal with the state of emergency. As I indicated, I will have each of the patrons of the bills present their bills. The bills are not identical. There's some that are very close, others that have some difference there, but they all deal with the state of emergency. So I'll have those 5 patrons present each of their bills. Then I will take public testimony as it relates to those bills, and then we will discuss the action to be taken on the bills. We'll start out with Senate Bill 5001, which is Senator Newman's bill.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to kind of go over at a high level what the bill does and go over in particulars as well. Mr. President, Mr. Chairman, as you know, we have been kind of dealing with a state of emergency now for 168 days today. There have been 18 executive orders. Many of them have been helpful orders. Many of us have been asking to come back into session. I know that there have been Democrats and Republicans that have asked to come back into session long before we got here now. And we have seen some major policy changes that have taken place. Mr. Chairman, as you know, the Code of Virginia that we pass adjustments to, if it were stacked high, it would be about 5 feet high on the rules and regulations that the legislature and the governors in the past have agreed on, and those are the laws that we live by. Mr. Chairman, however, there are 3 lines in 44-146.17 of the Code of Virginia that basically override the 5 feet of laws. And if you go into that section, it's an amazing section of the code. It basically, Mr. Chairman, as you know, gives the governor the ability to organize. In other words, be the director of emergency management and organize things. It gives him the ability to procure products and goods and services. It allows him in a paragraph to come up with a plan, a Virginia Emergency Operations Plan. It allows him to, in lines 28 through 32, to work on an evacuation, ingress and egress, a lot of things that are just critical. It does allow for a Class 1 misdemeanor of the violation of those items, no civil penalties. Mr. Chairman, then you get to lines 36 through 39, and that turns everything differently. And it really distinguishes Virginia in many ways, and not necessarily in a way that leads to a proper separation of powers. This section talks about the fact that there's an order and ability to quarantine and isolate for communicable diseases that may be determined. Mr. President, it is under that section that we have really had a large section of the Code of Virginia has been undone. And mine is not that I think that this governor or any other governor has any ill content, but I do believe that this Senate of Virginia and the House of Delegates should act to protect our constitutional separation of powers, and in the fact that we're going to live by the rule of press conference for a long time, we should come back into session. We should do what we're doing now. We should pass laws. We should enact items. We should have debates, and we should come up with what the laws are. We should not allow a single individual. If you go on and look at this code section a little more, it allows these activities of executive orders really to stay into effect until after the General Assembly meets, but then it really doesn't say anything about the fact that it couldn't continue on after that and just really be re-upped every year. As most of you saw in the Roanoke Times and other papers recently, they've said that bills of this nature have a lot of merit and we should be discussed. And in those reports, editorials, they basically were saying that look at other states. And you look at other states, there is some limitation on them. There is states that have very strong limitations. There are states that do it the way I might like to do it, which is that we would actually say after a certain amount of time, whoever the governor is, Republican or Democrat, they have to call the legislature back into session. Mr. President, you might ask, well, why didn't this bill do it that way? And that's because Legislative Services has indicated that that is, in their opinion, at least right now, a constitutional issue and have to be dealt with in a constitutional manner. So what can we do? I've put forward this bill. It's been in the hopper. I know many of you have seen it, a version of it for a long time. That says basically you have 30 days, and then if the legislature doesn't act, you have another 60 days. And I'm willing, and I think that we will probably have an opportunity before we leave these chambers to look at one that may be longer than 30 days. I would be okay with something that's a little longer, maybe 60 days, maybe 90 days. So, Mr. Chairman, that's what this bill does. This bill says that a free people should be governed by a legislature and the laws should be enforced by an executive branch. These three lines in the Code of Virginia turn that on its head. These three lines basically say that you can come up with an executive order, enforce it by a Class 1 misdemeanor on almost anything that is out there. So, Mr. President or Mr. Chairman, I'm hoping that you would think carefully about these items. I would tell you that if this committee doesn't quite see through to do one of these items, I think there are some other bills out there, the budget bill. There's another bill that came from another committee that the full Senate may get a chance to look at as well. But I think this committee should very, very carefully consider the entirety of Section 44-146, consider very carefully what legislative powers should be versus the executive, and come up with a compromise that allows us to go into executive orders, but allows us also a pathway to get out. Mr. President, or Mr. Chairman, there's a lot of other comments that I may save for the floor on another bill or if it's put into the budget, but that's, sir, kind of my thoughts on Senate Bill 5001.
All right, are there any questions of Senator Newman on his bill?
I have a question, Mr. Chairman.
Senator Mason.
Senator Newman, you've been here a long time. Have you, and certainly there have been several executive orders, emergency orders issued by the governor in that period. Have you ever seen anything even close to this?
Mr. Chairman, I have not. And here's the heartbreaking decision for me is if this was a Governor Alan McDonald or someone else, would I still be doing this? I hope so. I hope so. I hope so, but because I think this truly is a separation of power. I agree that this pandemic is different, Senator Mason, than others, and I get that, but I have not seen anything like this, and I I would say that I think if Virginia's constitution was constructed much closer to some other states, we could have strong executive leadership, but then also have a way for the legislature to get in. So the quick answer to your question is no, sir.
Thank the gentleman.
Are there any further questions of Senator Newman? All right. The next bill is Senate Bill 5008. Senator Suderline.
Thank you, Mr. Chairman, and thank you to the committee. My bill, Senate Bill 5008, is similar in intent to Senator Newman's. If you're looking at the bill in front of you, the relevant lines are lines 40 through 46, and there you will see that after the executive issues an emergency order, it is in effect for 45 days unless the General Assembly takes an affirmative action in support of that legislation, or in support of that order. This is something that, as the Roanoke Times pointed out, a majority of our sister states have similar legislative prerogative to step in and extend or not extend executive emergency powers. The whole premise is that an emergency is that it's an emergency. It's just like when you go to the hospital and you have to get the immediate action, and it's not something that you can have the full view of government to look at as you would usually want. I think that what we've had for some time now is, if you like it or not, the executive branch is single-handedly making law for some time. We were here in April, and I was hoping that we'd go into special session then. I thought we needed to take up some COVID policies at that time. And as I pointed out the other day, so did some Democratic delegates who articulated that. And I think there were probably some members of both parties in this chamber that also felt that way, but we did not do it. I have not heard directly from the executive branch on my bill, but they talked to a Roanoke radio station about it. And so I heard that they were not enthusiastic about my bill as presented, because this would mean all of the governor's emergency orders that he issued this year would have expired in May. That is not true. If this bill were the law of the Commonwealth in January, before all this happened, the governor would have taken the actions that he thought necessary in March. They could have continued through April. And when we were all here in this exact same room in April, we would have had an opportunity to vote on it. And they would have been able to say, you've seen how it's worked, you see why we think it should go more, and maybe the legislature says yes on this, no on that. But it would actually restore constitutional checks and balances again. And that's the bill, and I hope you'll act favorably.
All right. Are there any questions for Senator Suderline? All right. The next bill in this set is Senate Bill 5048, Senator Peake's bill.
Yes, sir. Mr. Chairman, you ready to hear from me?
Yes.
All right. Thank you, Mr. Chairman and members of the committee. This bill, and it follows similarly with Senator Newman and Senator Suderline's bill, but putting deadlines going forward, and I didn't want to copy them, but it arrives out of the same concern. And this pandemic hit for the most part in March. The governor declared a state of emergency in March. We're now 5 months past that declaration of a state of emergency, and there really is no indication whatsoever that he has any desire to remove us from this state of emergency. If you look at 44.146.17, it does talk about quarantine, but it talks about in time of disasters. He shall take such action from time to time as is necessary for the adequate promotion and coordination of state and local emergency services activities relating to the safety and welfare of the Commonwealth in time of disasters. Now, this is not a continuing disaster. It is a health problem, just like AIDS was a health problem, just like flu epidemics are health problems, just like other pandemics are health problems. It is not justification for an unlimited state of emergency. If you look at that law, it allows the governor at this point to go until June 30th of 2021 if we do not do anything. And similar to what Senator Newman said about his bill in dealing with LIS, I wanted a bill or a resolution that would state that we are no longer in a state of emergency, and LIS indicated that they thought there were constitutional problems with that. I honestly don't, but I think this body needs to stand up and be heard, the House of Delegates and the Senate, and maintain our authority. The governor, we have a very strong governor in the Commonwealth, which is why he's restricted to one term. And we are allowing the governor to do everything by executive order. It's been going on for 5 months, and at this rate, it will go on until June 30th. We're now here in session, special session. It started in August, 5 months after this. We can no telling how long we're going to be here, and there's absolutely no indication from the governor that he is going to quit governing 8.5 million people by executive order. We have to protect our autonomy of the General Assembly and for the people. And that's the point of this bill. It's a health problem, and it's certainly a serious situation, but there's no justification to keep ruling the Commonwealth by executive order.
All right, are there any questions of Senator Peake? All right, next is Senate Bill 5077, Senator Stanley.
Thank you, Mr. Chairman, members of the committee. I appreciate you hearing me on this bill. Senate Bill 5077 actually takes a good look and a critical look at Code Section 44-146.17. Ladies and gentlemen, in full disclosure, I must say that I've always wanted to come before one of these committees like Surivel or Chap Peterson does and say, I had this case, and now I need to change the law because I see how inequitably it has been applied. Well, I had this case. And some of you may recall that it wasn't too long ago, and I had co-counsel the gentleman from Hanover, and we had sought relief for a particular industry in the Commonwealth of Virginia that we thought was unfairly shut down by Executive Order 53 by our governor, using the powers granted to him under this code section. And so we had a court trial, we filed pleadings, and we sought an injunction. And in the court's order in denying the injunction, and whether I agree or disagree with the order, I did not agree with it, but certainly that's why we go to court to have these things happen. The court made a determination that I thought was striking. And you can see in Code Section 44-146.17 what I'm talking about. When I tell you that the court's order, specifically what the court said from the bench and also included in the order, that once an emergency is declared by the health commissioner, the governor has unlimited power. The governor, in fact, the court found, his power is only limited by his own judgment. Now, this is not personal to our current governor, His Excellency Governor Northam. It's not. But what we found is that in the code and the way it had been written at the time that it was written, intended to be for these type of emergencies such as natural disasters, pandemics, is that the writing itself granted unlimited power, and that power was only limited by the person who occupied the office's own judgment. In these type of situations, especially when we're talking about the balance of power, to grant any body to be limited by their own judgment and to have that power basically be unlimited, I think is unwise. And no matter who the governor is, Republican or Democrat, independent or otherwise, that I would be here if we had a Republican governor who had done what has happened and was unchecked in its authority and power. We as a state, as a commonwealth, were created by founding fathers who then modeled their form of government at the national level on the one they had created here. And one of the most important things that we all learn in civics and that we all understand, even having the honor and privilege of serving here, is that there are certain checks and balances that make each branch equal. That we in and of ourselves are not unlimited in our powers, and that the only limitation of our legislative powers is our own judgment. And so when you look at the code as it is written and in my bill, starting on line 18 of subsection 1, what I try to do is not rewrite, not to limit times, but just to make sure that the governor who would be sitting when an emergency is declared would have powers that specifically relate to this section and don't go outside of the rails on either side of this code section. The original form said, subsection 1, that the governor shall have, in addition to his powers hereinafter or elsewhere prescribed by law, the following powers and duties: to proclaim and publish such rules and regulations and to issue such orders as may, in his judgment, be necessary to accomplish the purposes of this chapter, including, but not limited to, such measures as are in his judgment. What the first part of this bill does is it trims those words out. So this now reads, to proclaim and publish such rules and regulations and to issue such orders as may be necessary to accomplish the purposes of this chapter and required to control, restrict, allocate, or regulate the use, sale, production, and distribution of food, fuel, clothing, and other commodities, material goods, services, and resources under any state or federal emergency services program. That is very specific. It limits the governor's powers to that and to that alone, and takes out the unending language of only regulated by his own judgment, that his power is absolute and unregulated. I don't think any governor should have that kind of power, no matter who it is. And I don't think when I'm governor, you want me to have that power, so I'm doing this for you.
What the heck?
Just kidding.
Gavel him down.
The second part of this, now when I look through this, we're not abrogating the purposes of the statute. Rather, we're bringing it down into its best form as it is intended to be. And so the second part that I seek to amend of 44-14617 is such as to the other powers that he has, starting on line 36, that he can execute such executive orders declaring a state of emergency, may address exceptional circumstances that exist relating, and I add the word, solely to an order of quarantine or an order of isolation concerning a communicable disease of public health threat that is issued by the state health commissioner for an affected area of the Commonwealth pursuant to Article 3.02, 32.1-48.05. Now, that's significant because once the health commissioner declares the state of emergency, the governor then becomes the director of emergency management. But the code section that it's referencing there is for matters of isolation and quarantine, which are extraordinary powers to declare isolation and quarantine in the Commonwealth of Virginia. And if you look in that code section, what it says is this: you can't just order isolation for the entire Commonwealth of Virginia. That's not how the code sets it out. You can't order a lockdown, shutdown, or quarantine of the Commonwealth of Virginia. That's not allowed. It is in those specific areas where the health commissioner and the director of emergency management have determined that there is an outbreak and a spread of a disease, a communicable disease, that is a public health threat. And so they can declare, let's just take Rocky Mount, Virginia, we're having an outbreak. Then the governor, in his authority under this statute, but granted in the previous statute I've just referenced, can declare an order of isolation or quarantine. But then the code is very specific that they must seek from the circuit court an ex parte hearing where evidence is adduced upon which the order of quarantine or isolation may be given. It's very specific, and then there's a reason for it. Because it provides due process to the people of that area. It provides due process to the businesses in that area. And it's a limitation of the governor's power, not an expansion of it. It is precision with a scalpel and not with a hatchet. And so what this does is it gives him the ability also to address those exceptional circumstances that exist when a pandemic such as this arises, but only in those orders of quarantine or isolation with regard to a communicable disease that's a public health threat in the specific areas. It is a protection to the citizenry. It is a protection to business by just adding the word solely. And more importantly, it's a protection to our democracy so that we do not have rule by fiat, so that we do not have one person making all the rules while this General Assembly is out of session. The greatest addition I make can then be found on line 40. And this is in light of the fact that we're going to lose, it is estimated, 21% or more of our small businesses. 21% or more of businesses in Virginia that were closed because of an order will remain closed. While Amazon went up, profits went up 100%. Home Depot's profits up enormously. Lowe's up enormously. Kroger not affected. And while we could all go to those places, while we all could visit them, and I remember in the beginning we weren't wearing masks and we weren't standing that far apart in those stores. And we never saw a hotspot outbreak at a Lowe's, Home Depot, a Kroger, or anything else. And the thing about that, Mr. Chairman, is that those were the places where everybody either went to, and a grocery store would be the number one place, or knew somebody who went there for them. And yet we did not have a spread of this pandemic through that. They were allowed to remain open, but small businesses were shuttered. Some of them with reasonable explanations, some of them with unreasonable explanations, some of them with no explanation whatsoever from the executive branch. So on line 40, what I try to do is to restore due process in the same way that we declare an order of isolation or quarantine in a region, in a Rocky Mountain, Spotsylvania County, city of Richmond. What we try to do here in line 40 is that an executive order issued by our governor under this statute shall not force the closing of any business or any category of business or industry, either temporarily or permanently, unless, it's not absolute, unless first, an order of quarantine or an order of isolation concerning a communicable disease of public health has been issued by the state health commissioner for an affected area of the Commonwealth pursuant to Code Section 32.1-48.05. And two, the state health commissioner and his legal representative, as soon as practicable following the issuance of that order, has filed a petition seeking an ex parte court review and confirmation of the legality of the exercise of such authority. Let me read that just again. A court review and confirmation of the legality of the exercise of such authority, which, ladies and gentlemen, is the hallmark of our system of democracy. The three branches, equal, checks and balances, making sure that one branch is not exerting authority it doesn't have over the other or over the people. Because many people who worked their whole lives for their small business to get their piece of that American dream, those lives have been shattered with the decisions, without review, without peer review, without judicial review of the executive branch. So what we're trying to do is to make sure that if you're going to close businesses or categories of businesses, then they are deserving of the same due process as a region would be. And that can be all taken up at the same time. Because again, ladies and gentlemen, I mean, I don't understand how we came to essential and non-essential businesses. Those determinations, picking winners and losers. And for the winners, it's been great because competition has fallen away because the losers were closed. It's not fair. It's not American. And so I think that's a very important thing that we need to have, where we bring back into balance legislature, the judicial, and the executive as one. Finally, you will note that the only things that I have done is rearrange some words and take out some words and add some words in lines 48, 47, 48, 49, 50, 51. This paragraph reads, except as to emergency plans issued to prescribe actions to be taken in the event, and I've added the word natural disasters, because that is also where the governor has the executive authority to act when an emergency is declared. No rule, regulation, or order issued under this section shall have any effect beyond, and it said June 30th, next following the next adjournment of the regular session of the General Assembly. That's a long time. Rather than putting a limit of 30 or 45 days, my bill simply does this. In the event of a natural disaster and emergencies, an emergency would fall, this pandemic would fall under that emergencies. No rule, regulation, or order issued under this section by our governor as the Director of Emergency Management shall have any effect until the adjournment of the next General Assembly session. Until the convening, of the next General Assembly session. That way, again, the checks and balances of government are working together, not separately. That we do not have one branch making all the decisions, but working in unison as we should always be. This also permits that after the adjournment of the General Assembly, after it adjourns, the governor declaring an emergency can then reinstitute those rules, regulations, or orders after we've gone home. It does not eliminate the governor's power. It wisely limits his power, because no governor, man or woman, should ever have unlimited power that is only checked by his or her own judgment. It should rather be checked by our delicate balance of democracy. And that's what this bill tries to achieve in a very minimal way, but a very direct way. And I think it is important for us moving forward when these things happen in the future. And I thank you, Mr. Chairman, for your time.
Thank you, Senator Stanley. Are there questions for Senator Stanley? Senator Evan.
Yes, thank you, Mr. Chairman. Briefly, your bill has the review of a court review when the governor seeks a quarantine or order of isolation for an affected area or closes a business in that circumstance. When you sued for, if I got this right, when you filed a lawsuit on that basis, didn't the court rule that the governor had the authority to do that?
Mr. Chairman, I'd answer the gentleman by saying there has never been one order issued of isolation or quarantine by this governor. Because to do so in the manner that he did, he would have had to gone to every jurisdiction, every circuit throughout the Commonwealth of Virginia and file petitions in order to shut these businesses down or isolate or quarantine the citizens of Virginia. That did not happen.
I'm sorry, just to follow up.
Senator Evan.
It was my understanding that you filed a lawsuit at least in one circuit that his ability to have that order was affirmed. Is that not the case?
Can you repeat the question? Mr. Chairman, I'd ask
Senator Stanley.
if he could repeat the question for me.
Did you file or another attorney file a lawsuit in a circuit that the court upheld the governor's authority to take the action that he took? Is that not the case?
Mr. Chairman, the court upheld the governor's action because it didn't fall under quarantine or isolation under 32.1, 48.05. And as the court found in its order, plainly stated that once he becomes the Director of Emergency Management and once health emergency has been declared, then this statute, before these proposed amendments, gives the governor unlimited power that is only limited by his own judgment. What he should have done is issue orders of quarantine and isolation in each area. Instead, he just ruled by executive order. He gained the power, as he cited even in his executive orders, from this statute and from the other parts of the code. But he didn't follow the code in the sense of those orders which he had weren't pursuant to isolation or quarantine. We already have that, and those weren't followed. What he did was he went outside of that and just said, since I'm not limited in my powers, once I declare this emergency, I can do anything I want for as long as I want, and I just don't think that's right for any of us. And I'm not making a value judgment of our current governor on that, okay? I understand that's a tough situation, tough call.
All right, thank you, Senator
Mr.
Sanders.
Chairman.
Are there other questions? Yes.
Mr. Chairman, move to PBI the bills.
We still have one more bill to go.
Ready to move on, Mr. Chairman.
King George is in the back, I see.
Are there any other questions of Senator Stanley? All right, Senator McDougal.
Thank you, Mr. Chairman. Mr.
5111.
Mr. Chairman, Reagan and I went to church on Sunday and read Romans, and one of the things in Romans 12 talks about the spiritual gifts that each of us have. And she was asking me this morning what her gifts were. And I said, well, you probably don't have the gift of prophecy, but I sure do right now know where this is going to go. Mr. Chairman, that was made abundantly clear. Mr. Chairman, I'm not going to be as verbose as some of my colleagues have been, but I do think this is an important issue. Right now, under the Code of Virginia, the governor can issue an executive order, in essence, in perpetuity. In perpetuity. They have to come back every July 1 and reissue it, but as long as they issue it, it's there. Mr. Chairman, this body and the other more numerous group should be making law, not a governor by themselves. And Mr. Chairman, I know the gentleman from Lynchburg wonders if it had been a different party, if he would have felt the same. Mr. Chairman, I would. We've had those discussions, disagreements with members of our own party. This body should stand up for our authority and pass some legislation that makes it abundantly clear, if anybody has a doubt, that law cannot be passed by one governor, by fiat, by one governor in perpetuity, and this body would have to have a vote.
All right, are there questions of Senator McDougal?
Mr. Chairman, Senator Reeves.
Senator Reeves.
Yes, Mr. Chairman. Senator McDougal, would you agree that the longer an executive order is in place, the least effective it becomes because it's no longer considered an emergency?
Mr. Chairman, I appreciate the gentleman not asking me to cite the rest of that passage in Romans. But, Mr. Chairman, when you look at the beginning language of executive orders under that code section, it talks about there being an emergencies. The way the code section is set up, there is no time limit except July 30th of each year. So an executive order issued on July 1st of 1 year does not expire for 364 days unless the governor puts a time frame on it, or can be renewed in perpetuity as that goes forward. So even though there is references to emergencies, there is no requirement under the time frames that they have to expire, or that the emergency, when that emergency is determined or not, it's only in the governor's judgment. That's the only limitation.
Thank you. Mr. Chairman, when the time is appropriate, I'd like to speak to the bills.
All right, are there further questions of Senator McDougal? All right, then the floor is open for discussion or motion.
Mr. Chair.
Mr. Chair, I'd like to
Senator
speak to the bill
Reeves.
before we take on.
Senator Reeves, did you want to discuss?
Yes, Mr. Chairman, I would just like to state that when you look at what the Commonwealth typically has to deal with, we're going to be dealing with an issue coupled with the pandemic probably in a few days. It just made its landfall in Louisiana, and if you look at the trajectory, it's heading our way. And those are hurricanes. And when you look at hurricanes, Mr. Chairman, and you look at Katrina or Sandy, the average recovery time for those after those devastating hurricanes is about 14 months. But within about 3 months, you have the peak of the remodeling being done. So 3 months is probably where people are trying to get housing back and such. Because, you know, we all understand this is a pandemic, and whoever wrote the bill back when I think it was 2004 probably couldn't foresee something of this nature. But I would like to commend my colleagues for trying to get to the table to figure out how do we do that where we don't lose our voice in the General Assembly. Because many of you I've talked to, as well as myself, have heard from our constituents of how long do we stay under this, quote, executive order, or as some view it as martial law. And I truly think people are tired of being in a pandemic mode. I think that's part of the reason why we have some of the unsettling riots and stuff. If you look at typically the Watts riot back in the 60s in California, what caused that, and riots across the country, yes, there was a catalyst of police brutality and other things happening, but that's coupled with people being smacked indoors, in close quarters, in heat of the summer, and those sorts of things. And so I think this is a valid set of bills to actually have a discussion about, regardless of who's in power. We do have elections, and those have consequences. We all know that. But these are extenuating circumstances, and I think we need to take a valid look at these rather than just shove them in the drawer and say, no, not this time. I certainly know that several of my colleagues would bring these bills if it was Republican or not, just because of those checks and balances. So that's all I wanted to say, Mr. Chairman, and thanks for letting me attend the meeting today.
Certainly.
Mr. Chairman?
We do have one person who's signed up to give testimony, and that's Rita Davis with the governor's office.
Good afternoon, Mr. Chair and members of the committee. Can you hear me?
Yes.
Thank you for giving me the opportunity to speak on behalf of the administration. I will not take much time other than to say that the governor and the administration believes that the language in all of these bills pose a dangerous threat to his ability to assess and respond to and mitigate emergencies. As we all know, not all threats to public health and safety arrive in the form of turbulent wind or flooding rains or fast-moving funnel clouds. Some of them arrive as persistent, indiscriminate, aggressive microscopic organisms that linger in the air and on surfaces that cause just as much death and bodily injury. We have nowhere other to look than at this esteemed body to understand that these are unprecedented times because of the measures you have undergone to just meet together. This pandemic is not just a health problem. It is a prolonged emergency. And it's been prolonged for more than 30 days, more than 60 days, more than 90 days. And this is exactly the sort of emergency that the statutory language allows a chief executive to respond to. It provides him the flexibility to maneuver and protect the lives of Virginians in times just such as these. For those reasons, the administration strongly opposes reporting out these bills. Thank you, Mr. Chair.
Mr. Chairman?
Mr. Chairman.
Mr. Chairman?
Mr. Chairman. I have a comment.
Mr. Chairman, thank you. If we look around the country at the number of executive orders governors have had to put in, Republican and Democrats, obviously this is an extraordinary time and it's called for extraordinary measures. And as Senator Boysko and I were looking at this around the country, both Republican and Democratic governors, I think what our governor has done is basically what had to be done. And any bills that would restrict the governor's powers or hurt the governor's ability to do this, I think would be very dangerous. In Michigan, there were 168 executive orders, Mississippi 117, Arizona 53, Montana 41, New Hampshire 65, New Jersey 78, Tennessee 58. What we've done here, if you look at our executive orders, what our governor's done is in line with that. And again, restricting our governor, putting handcuffs around him. And this time, I think regardless of who's Republican or Democrat in the mansion is the wrong thing to do. And with that, I renew my motion to PBI these bills.
Second.
Let me go to Senator Kagan. She was ready to speak previously, so.
Thank you, Mr. Chair. I'll just be brief. I would say, ever since March, we've been living, again, as people have said, unprecedented times with a lot going on. There were many days where I was not envious of the governor and some of the decisions he had to take. And I hear, what the speaker in opposition said about taking away his powers, but I don't feel like it's actually doing that. We're still letting him have that power to do the emergency enactments, but it just limits it after a certain amount of time. We actually went through and looked at what other states have done, and that seems to be a theme today of how many states are doing what. And we are one of 8 states that we could tell in their nation that does not restrict our governor's ability to declare or to have this emergency powers authority. So we are absolutely in the minority. We got email after email and social media comment and phone call after, hey, why are you not doing your job up there? Why aren't you doing anything? When are you going to do something? Because my constituents, and we didn't even ask the party affiliation, but just got tired of living press conference to press conference. They say, what's going to happen next? And I said over and over, well, I don't know what's going to happen next. We're not involved in the discussion. So we too find out when you find out at the press conference. So it was really government by press conference, and this just gives us a say in things. And I too believe in the balance of power, and we're representative government, and our democracy is set up so that we balance each other out, so that one branch does not have sole authority to declare things. I know that, at least in my region, one day we turned around, the beaches were all closed. Well, that's a main source of income, all the tourism and just all the people that come down to the beaches. And then a couple weeks later, we turn around, well, the beaches are open, but you guys can't have radios, you can't air coolers, you can't have a certain number of umbrellas together, you can't play frisbee. So people are like, why these rules? Why can't you do anything? I was powerless, really. I kept having to remind people, I don't have input right now. That's not how it works in Virginia. So I think there's a lot of room for improvement here, and I would definitely like to see us just do better with balancing that power. In 30, 45, 60 days, whatever we can agree to. But I think there's a lot of good ideas out here that need to be considered. Thank you.
Thank you. Senator Bell, did you want to make a motion?
Move to PBI.
Right.
Mr. Chairman,
Let me call on Senator.
Thank you.
Donovan.
Thank you, Mr. Chairman. I want to comment on this because I think it's really, really important. And I as a body, I am always so impressed with the Senate and with my colleagues on both sides of the aisle. But this is a really important conversation that's being derailed in a litigation of decisions that were made this year. And that is the wrong conversation to be having right now. This has been an extraordinary pandemic. It's unlike anything we've ever seen before. In the scope of our memory, we can reference things that happened 100 years ago if we want, but none of us have seen this before. Most of the emergencies that we see would be hurricanes or something else, which is a short-lived intervention that everybody understands how that's going to unfold and what's going to happen. And that's one of the major differentiating points about what we're dealing with now. Every one of us, every 4 years, stands with our right hand raised and swears an oath to our Constitution. And I'm going to tell you that our Constitution very clearly says, in Article 3, Section 1, departments to be distinct in division of powers. And it says that they shall be separate and distinct so that none exercise the powers properly belonging to the others, nor any person exercise the power of more than one at the same time. It's our Constitution, guys. We are 2 parties, but we are one Senate. And as the Senate, we have a moral obligation to uphold this Constitution we took an oath to protect and to speak for our constituents. The voices that we offer in debate at this assembly are different than the issues the governor has to deal with as an executive and an administrator of many agencies. And both those conversations are imperative to us getting this right for Virginia. This is really important. I want to point out that in the code section right before any of the bills that are before you today, which is 44-146.16, it defines what an emergency means. It means any occurrence or threat thereof, natural or man-made, which results or may result in substantial injury or harm to the population, goes on to identify that a little bit more. And then it basically says that cannot wait, cannot be complicated by, excuse me, let me just read it. Damage to or loss of property or natural resources and may involve governmental action beyond that authorized or contemplated by existing law because governmental inaction for the period required to amend the law to meet the, I can't even say it, would work, immediate and irrevocable harm on the citizens or the Commonwealth. So I'm sorry I read that so poorly, I'm a little tired, but the bottom line is it says the governor may act when we cannot be there. That is not in perpetuity. We can be here. We should be here. We should have a division of power. We should have a conversation. I know there are a lot of bills before us. I don't think we should lump all this stuff together and talk about it separately. And I think, I find the bill that I think resonates most profoundly with the changes we need to make. This is code, guys. This is not the Constitution we're talking about changing. When we're talking about this code section, we refine the code section all the time when we find out circumstances prove to us that that code section needed some tweaks. We need some tweaks. We don't need to be in perpetuity waiting at the will of the governor to be called back. We should be able to have a conversation about, let's be honest, you could have outvoted us at any assembly we had this summer. You have all the votes. This isn't an issue of what's going to happen. It's an issue of whether or not our constituents are heard. That's what's happening here this week and next week and the week before. And we are suppressing that by not ensuring that there are limits on how long a state of emergency can go on without a conversation from the legislature. I particularly support Senator Newman's bill. I think it is very clear. I think 45 days, when you think we're usually talking 5 or 10 days for a hurricane, 45 days is a very reasonable amount of time. And I would beseech you to give some serious consideration to what we're saying here, because this is really important. And sometimes we have to make decisions when we are or we are not the party in power that affect how Virginia runs from that time forward. And this is the right decision to make for Virginia, and I challenge you to make the right decision. I hope that you will pull out Senator Newman's bill from the block that you want a PBI, and that we will consider that separately and take a voice vote on it if it fails.
Is there any further discussion on the issue?
Briefly,
Yes.
to close.
Senator Suderline.
Thank you, Mr. Chairman. Thank you for the opportunity just to close briefly. There's been a lot of discussion. I just want to point out in regards to the comments made by the senator from Loudoun, when we talk about all these other states, the majority of states have something along the lines of what's proposed here. That's what the Roanoke Times editorial highlighted, is that the majority of states have these laws. And over again, we hear from some of our most senior members that Virginia is sometimes slow to be like the other states on some things that we ought to do. This is a very reasonable approach that would give us a constitutional balance to government again.
All right, is there any further discussion on the bills? Are there motions to be made?
I'll move again to PBI all the bills.
Second.
All right, we have a motion and a second to PBI.
Substitute motion.
Substitute motion offered.
Move to report.
Move to report.
think we've discussed that before, and that's not the case, Senator Ruff.
Yeah.
Mr. Chairman, I move that we consider the bills individually, please.
All right, we can take action on each of those individually then. All right, Senator Bell, I'll call on you on Senate Bill 5001.
Move to PBI.
Second.
All right, there's a motion and a second to pass by indefinitely Senate Bill 5001. Is there further discussion as it relates to Senate Bill 5001? All right, would the clerk call the roll?
Senator Ruff. Senator Locke. Senator Vogel.
To PBI, no.
Senator Eben. Senator Reeves.
No.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko.
Aye.
Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggin.
No.
Senator Barker.
Aye.
8 ayes, 6 nays.
Just a second. Ayes, 8 ayes and 6 nays? Is that what you had?
Yes, sir.
Yes, okay, then the bill is passed by indefinitely. That brings us to Senate Bill 5008 from Senator Suderline. Is there a motion?
I move to report.
Substitute motion, move to PBI.
All right, we had a motion to report and a substitute motion to pass by indefinitely. Is there a second on the substitute motion? All right, there's a second on the substitute motion. If there's no further discussion at this time, then we will have a clerk call the roll on the substitute motion to pass by indefinitely Senate Bill 5008.
Senator Ruff. Senator Locke. Senator Vogel. Senator Vogel.
Sorry, did you say Vogel?
Yes.
Oh, no. Sorry.
Senator Eben. Senator Reeves.
No.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko.
Aye.
Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins.
No.
Senator Barker.
Aye.
8 ayes, 6 nays.
8 ayes, 6 nays. Senate Bill 5008 is passed by indefinitely. Next bill is 5048 from Senator Peake.
Second.
All right.
Good motion, move to report.
All right, we have a motion to pass by indefinitely, and we have a substitute motion offered to report, so we will vote on the substitute motion to report. Clerk, could you call the roll?
Senator Ruff. Senator Locke. Senator Vogel. Senator Vogel.
Sorry, can you not hear me?
We can hear you now.
Okay. You were breaking up. The motion is to PBI? No.
The motion is to report.
Oh, sorry. Aye.
Senator Eben. Senator Reeves.
Aye.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
No.
Senator Kiggins.
Aye.
Senator Barker.
No.
Ayes 6, noes 8.
Okay, that failed. To go back to the original motion, which is to pass by indefinitely. If there's no discussion, we can call the roll on that.
Senator Ruff. Senator Locke. Senator Vogel.
No.
Senator Eben. Senator Reed.
No.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins.
No.
Senator Barker.
Aye.
Ayes 8, noes 6.
All right, the motion to pass by indefinitely, Senate Bill 5048 passes. Senate Bill 5077 from Senator Stanley. All right.
Second.
All right, we have a motion to pass by indefinitely. It was seconded, and we have a motion, substitute motion to report, and that was seconded, so we will vote on the substitute motion to report. Clerk, would you call the roll?
Senator Ruff. Senator Locke. Senator Vogel.
Aye.
Senator Eben.
To report.
Senator Reed.
Aye to report.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
No.
Senator Kiggins.
Aye.
Senator Barker.
No.
Ayes 6, noes 8.
All right, that bill failed to report, so the motion, go back to the original motion, which was to pass by indefinitely. Clerk, would you call the roll?
Senator Ruff. Senator Locke. Senator Vogel.
No.
Senator Eben.
Yes.
Senator Reed.
No.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins.
No.
Senator Barker.
Aye.
Ayes 8, noes 6.
Ayes 8, no 6. Senator Bill Stanley's 5077 is passed by indefinitely. And then the last of these is Senator McDougal's 5111. Is there a motion? All right, we have a motion to pass by indefinitely, a substitute motion to report. Clerk, would you call the roll?
Senator Ruff. Senator Locke. Senator Vogel.
To report, aye.
Senator Eben. Senator Reed.
Aye.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
No.
Senator Kiggins.
Aye.
Senator Barker.
No.
Ayes 6, noes 8.
Ayes 6, noes 8. The motion to report failed. We go back to the main motion, which is to pass by indefinitely. Call the roll, clerk.
Senator Ruff. Senator Locke. Senator Vogel,
No.
Senator Eben. Aye. Senator Reeve,
No.
Senator McPike, Senator Donovan, Senator Mason, Senator Boysko, Senator Stewart, Senator Pillion, Senator Bell, Senator Hashmi,
Aye.
Senator Kiggins,
No.
Senator Barker.
Aye.
Ayes 8, noes 6.
Ayes 8, noes 6. That bill also is passed by indefinitely. All right, we have 4 more bills. Hopefully none of these will take too long. Senate Bill 5039, Senator Morrison. And this bill, if it is reported, would need to go to Finance.
Thank you, Mr. Chairman. Senate Bill 5039. Ladies and gentlemen of the Senate, with no clear end in sight for this COVID crisis, Medicaid providers, developmental disability waiver providers, and small businesses continue to struggle with access to and the cost of personal protective equipment and need consistent and continuous access to PPE at reasonable cost. That's the problem this bill is trying to solve. And the solution is that this bill gives the governor the authority to create a centralized program to procure and distribute PPE among private, non-governmental entities while being reimbursed. And the governor can, certainly the administration can be, and the state can be compensated for its time and trouble in terms of providing this service to folks. The program allows the Commonwealth of Virginia to act, should the governor choose, as a scale purchaser and distributor of PPE, which will drive down the cost and ensuring prioritization during a global supply chain shortage. I don't know about all of you, but during this pandemic, I was actually in conversations with people that said, do you know someone in China? Do you know someone in South Korea? Can you help me get PPE? And what this is an option. It's not something the governor has to do or is required to do. It just gives him a tool that he can use should it become necessary as this pandemic continues or as a new one at some point in time replaces it. These businesses, these smaller businesses, are in difficult situations. How hard would it be if you have a small company to have somebody spending all day on the phone trying to procure PPE when perhaps the administration could do that on your behalf if the governor so chooses to do so? That is the bill. It's supported by the Medical Society, the Orthopedic Society, the American Society of Pediatrics. And, Mr. Chairman, it is merely an option for the governor, doesn't require anybody to do anything. But as we learned in this last pandemic, we need options. We need things that people can utilize to help our frontline workers and businesses to provide the necessary equipment to keep those people safe. And that is the bill, Mr. Chairman.
All right, are there any questions of the patron?
Mr. Chairman?
Yes.
When it's appropriate, I'd like to make a motion.
All right, is there any other questions? Any discussion? All right, Senator Elbin.
I move to report.
All right, we have a motion. Is there a second? And a second to report the bill.
Mr. Chairman, does it have to be re-referred to Finance?
And re-refer to Finance.
Report and re-refer.
All right, to report and re-refer to Finance.
Mr. Chairman?
Yes.
Senator Reeves.
Senator
Just
Reeves.
a question for the patron real quick. Yeah, real quick question. On your bill on line 180, it already gives some authority to the state coordinator of emergency management, of VDEM, to procure supplies and equipment. Why do we need to go a secondary step and have the governor be able to do it if he's already got his point person that's in charge of with the ability to do that?
I'm sorry, Mr. Chairman, I could not hear the Senator Reeves' question.
So on lines 180 of your bill, it already allows the VDEM or state coordinator of emergency management to procure supplies and equipment. Why do we need to take it up a level higher for the governor to be able to do that when his point person can already do that?
Line 20.
That was line 180, I think you referred to?
180 and 81.
Oh, thank you. Line 20 talks about the retirement service. I'm sorry, 180?
Correct.
Okay, hold on. Mr. Chairman, I believe the answer to the gentleman's question is that that only provides to people who are responsible to emergency medical services, and that would not be DD waiver providers and others, I do not believe.
Okay, thank you.
All right. Are there any other questions?
Mr. Chairman?
Yes.
I don't
Senator
have a
Donovan.
question. I'll just make a comment. This has been an area of immense confusion. PPE was distributed in a very different way after the state of emergency than before. And first it was federal, and then it was state. And then there were errors of omission that people were excluded, like private ambulance and now mental health. And so to have some sort of centralized system, I'd prefer something like a private public. But somehow we've got to have so many people in the Commonwealth were told, here are the list of vendors, go find your own. And it was a real crisis for Virginia. So, I'm not sure this is the solution, but I support a solution, and this is one. And so I think we have to figure out if we can spend some money out of the Coronavirus Relief Fund to do it. But if we can, I think this is something we have to do, especially for schools and child care centers. Thank you, Mr. President. Mr. Chairman.
All right. Are there any other comments or questions? All right. We have a motion to report and to re-refer to Finance and Appropriations Committee. Clerk, would you call the roll?
Senator Ruff. Senator Locke. Senator Vogel. Aye. Senator Evan.
Aye.
Senator Reeves.
Aye.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggin.
Aye.
Senator Barker.
Aye.
Ayes 14, no 0.
All right. The bill is reported and re-referred to Finance and Appropriations Committee. All right. Next is Senate Bill 5012. And if that bill moves forward, it will also need to go to Finance and Appropriations. Senator Suderline.
Thank you, Mr. Chairman. Senate Bill 512 provides that the votes of the Virginia Parole Board shall become public records and subject under the Freedom of Information Act. When you look at the bill itself, it's a relatively short bill, but the relative language is lines 15 through 30. As you can see, or well, actually lines 15 through 23. As you can see, the Parole Board is already subject to FOIA for things related to finance and guidance documents and things of that nature. This would simply provide that their votes are also public in the same way that the votes of pretty much every board in Virginia are also public. It's a sunshine initiative. There's been some issues with the Parole Board, and I think things like even minutes not being kept, which that's not the most significant issue that's at the Parole Board, but when you're not keeping the minutes, it's a problem of any organization to see how it's being run. And perhaps part of the reason that the minutes weren't kept that tightly is because the minutes aren't that relevant if they don't even have the votes in them. But more important than just cleaning that issue up is we should know how these folks are voting. The Parole Board, as everyone knows, votes on very important issues that determine an individual's liberty and the public safety at a larger issue that affects 8.5 million Virginians. It's something that they should know about, and I hope it'll be a pleasure of the body to act favorably.
All right. Are there any questions for the patron? All right. We have one person who's signed up to speak, and that's Megan Ryan.
Thank you. Thank you, Mr. Chair, for giving me this opportunity to express my support of Senate Bill 5012. My name is Megan Ryan, and I'm the Executive Director of the Virginia Coalition for Open Government in Williamsburg. Many years ago, the Parole Board, the Crime Commission, and a few other entities were taken out of FOIA completely. They don't have to follow FOIA's rules for disclosing records or to the public or for holding public meetings. In 2017, recognizing the black box that important information was being hidden away in, Romanets 1, 2, and 3 on lines 15 through 22 were added by legislation patroned by Delegate Patrick Hope and approved by both Senate and House with only one no vote. The recent heavy redaction of the Inspector General's report on the parole board again laid bare the problems that can be masked when you give an entity near total confidentiality of its operations. So virtually, as Senator Suderline already said, virtually every other public board or commission in Virginia at the state or local level has to make their votes public. If we can't yet fully subject the parole board to FOIA, which I wish we could do, the least we can do is pass this bill and make the parole board votes available to the public. So thank you for your time, and I thank Senator Suderline for bringing this bill.
All right. Is there further discussion? Senator Boysko.
Thank you, Mr. Chairman. Speaking to the bill, I have had some conversations with the administration about this, and I understand that there are concerns. Specifically, the board communicates and discusses as one voice. And when we separate people out, there have been some issues where individual parole board members have received threats because of some high-profile decisions. There's a concern that if these individual votes are published and posted publicly, that members may be targeted before or after the vote, which raises a little bit of concern for me. And there could be an opportunity for people to try to influence the board members' votes to get them to vote in a certain way, which could impede the integrity of the process. And it's really important to understand that each individual case is unique. The board members review extensive information about an individual's history, institutional adjustment, maturation, and all of these things to put their decisions together. The information is often nuanced, and the public does not necessarily have access to the breadth of information that the board members do. And making individual votes public will not help the public necessarily understand why each board member has come to the decision that they have made. Again, I want to just go back and reiterate again that individuals who are serving the Commonwealth on this board have been subject to threats, which I think we all need to take seriously. And I would just ask us all to be cognizant of that as we make our decision about this piece of legislation. Thank you, sir.
All right. Are there other questions? Are there other comments or questions?
I just have
Senator Donovan.
If I may, a question for Senator Boysko.
Certainly.
So I'm just curious, Senator Boysko, if they received threats, but yet the votes weren't public. So individuals receive threats whether it's public or not. Is that accurate?
Mr. Chairman, Senator Donovan, I don't have that information.
Mr. Chairman, assuming that the votes have been non-public before, I think we're grappling. We've had other legislation that came here through just, I think we debated it today, although all the days blur together, so it could have been yesterday, where we're talking about transparency in law enforcement and other things. I think that people should know that there is an accountability for votes that they are taking, and that's a way for us to really improve the accountability for making hard decisions. And I have to say, on many of the parole board decisions I've heard of lately, I'm at a loss to understand any of the discerning process that was pursued in some of those cases. So, Mr. Chairman, I don't think it actually changes the risk of serving on the parole board because people have already received threats, but it does change the accountability, and it changes the ability for transparency and a better understanding for the public. So I hope you will support this bill.
Mr. Chairman?
Yes.
Just to follow up on this, my understanding is that the board as a whole has received threats, and they have not been targeted at individuals at this point. Threats could obviously be more serious if they were targeted at specific individuals, and also wanted to point out that the parole board did not redact the OSIG report, that the OSIG redacted that report, which was also something that's come up. Thank you.
All right, are there further comments or questions? Senator Abbott.
Very briefly, I think the Senator Boysko hit the nail on the head. The parole board is making individual decisions based on people's behavioral records of incarcerated people that are not available to the general public. So it's really hard to know how you're going to evaluate a parole board member when we don't know all the information that they had in making a decision. And I share the concern about, the parole board shouldn't be a political decision to, their votes should not be political based on public pressure. It should be based on really a careful evaluation of the safety of the community and the progress of the incarcerated individual. And I don't think that saying parole board member A voted not to parole this person or voted to parole this person furthers that discussion. I think their decision should be treated as a whole in examining it. Thank you. So with that, I'm going to move to PBI the bill if it has not already been moved.
Second.
Okay, we have a motion and a second. Is there any further discussion? Senator Sudeline, would you like to comment?
Chairman.
Make a final case? Yes.
Mr. Chairman?
Oh, Senator McPike.
If I can just have a comment before the patron closes.
Yeah.
I was very supportive of and voted for Senator Obenshain's bill, I think improving some of the process. I'm not sure that this is something that we have to act on in special session. I would certainly consider it when we have more information during regular session, but I'm not sure I'm in a position to support the effort, although I appreciate, I think, the patron's intent behind it. I'm concerned about some of the unintended consequences that my colleagues have cited. Thank you, Mr. Chairman.
Mr. Chairman, just before the patron closes, sure. I want him to have the last word. I would agree. I hope we look at this again because I think there's two ends of the continuum you can look at. Parole board members, you don't want them to be coerced into making a decision because they're singled out. On the other hand, you don't want people hiding behind the shroud and the cape of being one unified vote that they don't have to be accountable for. And somewhere in that continuum, there's a place that has appropriate accountability to the public, and I don't think we're there yet. So we need to find a way to move this forward. So I'll be interested in looking at that too.
All right. Are there any other questions or comments before I turn to Senator Sudeline? Senator Sudeline.
Thank you, Mr. Chairman, and thank you to the committee for your time this afternoon. The bill, as I said, it will make it very clear the votes that the parole board members take, just like the members of every other board. The discussion about the folks making these decisions have information that other folks don't have. I mean, sometimes I feel, wouldn't that be great if that could be how everyone understood each vote we take and everything that folks on city council and planning commissions take. But the reality is we're acting with responsibilities to the public as a whole, to the 8.5 million people in the Commonwealth. And when someone is charged with one of these very serious crimes of who's actually eligible for parole at this point in time, it means that they committed a crime that they were sentenced so long ago that they're still serving. They know who the police were. And when there was a bill a few years ago that wanted to try to conceal the identity of the police, that was something I strongly opposed, despite some folks on my side of the aisle saying we need to protect police officers. I believe we need to protect everyone, but I believe that police officers have significant power, and in that case, it would be irresponsible for us to hide that. They know who the prosecutor who prosecuted them was. They know who the judge who sentenced them was. If they committed one of these serious crimes that is a felony, there's a decent chance it went on appeal, and they also know how the judges at the appellate level voted. It's to say that we need to protect this one group of people from any responsibility because there's harm that could happen. I don't think that's the case. I think this is something that we should know how the parole board's voting, just like every other board. And I hope it'll be the pleasure of the committee to advance the bill.
All right.
Substitute motion, move to report.
Okay, we have a substitute motion to report and a second to that. Is there any further discussion? Clerk, could you call the roll on the motion, the substitute motion to report?
Senator Ruff. Senator Locke. Senator Vogel.
Aye.
Senator Eben. No. Senator Reeves.
Aye.
Senator McPike. No. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
No.
Senator Kiggin.
Aye.
Senator Barker.
Aye.
Ayes 8, noes 6.
Ayes 8, noes 6. The bill is
Mr.
reported
Chairman.
and re-referred to finance.
Chairman?
Thank you, Mr.
Just-
Chairman.
I'm sorry. I've messed up.
What's that?
Give me 1 second. I'm sorry.
Okay.
Mr. Chairman, in the meanwhile, I do have a question. If, if this bill is looked upon favorably, why does it have to go to finance? I've read the impact statement and it says that it's likely a savings because it transitions from a misdemeanor to a civil penalty, and therefore there's no fiscal impact.
Wait. You're talking about, I think.
You're on the wrong bill.
My bad.
Yeah, that's a different bill. All right, correction, the vote was 7-7 apparently on the motion to report. Is there any other motion anyone wishes to make?
Move to pass by indefinitely.
All right, the motion, we have a motion to pass by.
I'm sorry. Yeah.
Yes.
Just remember there's one more bill I was supposed to support. So, hope I haven't missed it.
All right, is there any discussion on that? All right, clerk, call the roll on the motion to pass by indefinitely.
Senator Ruff. Senator Locke. Senator Vogel.
No.
Senator Eben. Yes. Senator Reeves.
No.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins.
No.
I'm sorry, Senator Mason? No. Thank you. Senator Barker?
No.
Ayes 6, noes 8.
All right, Senator Mason, On the motion that was the first one we voted on this one, to report the bill, did you vote aye or nay?
To report the bill, sir, I voted aye.
Aye. Okay, I think the bill then passed on a vote of 8-6.
That's what I thought he said.
Did it? Did it pass?
Yes, sir. It was ayes 8, no 6.
All right.
I apologize.
8 ayes and 6 noes on the original motion that we voted on to report the bill and refer to finance.
Thank you, Mr. Chairman and
So
the
this
committee.
bill is reported and referred to finance. All right, we got 2 more bills to go. Senate Bills 5031 from Senator Locke.
Thank you, Mr. Chairman. Senate Bill 5031 is a fairly simple request. Earlier this year in June, with thanks to Pharrell Williams and the Virginia Legislative Black Caucus, Governor Northam and others, for the first time, the Commonwealth of Virginia recognized the importance and significance of Juneteenth this year. And what this bill does is to continue to recognize the 19th day of June of each year, also known as Juneteenth, as a legal holiday in the Commonwealth to commemorate the announcement of the abolition of slavery, in the last Confederate state, which was Texas, which abolished slavery well after it was abolished in every other state, and to recognize the significant roles and many contributions of African Americans in the Commonwealth and the nation. And that's what the bill does.
All right, are there questions of the patron? All right, we do have one person signed up to testify, Asif Bagnagri.
Good afternoon, Chairman Barker, members of the committee. My name is Asif Bagnagri. I serve as the Assistant Secretary of Administration. I'll be brief. We thank Senator Locke for putting forth this legislation, and the administration strongly supports the bill. Thank you very much for your time.
All right, are there any questions on or comments on the bill? All right, does anyone want to make a motion?
Second.
All right, it's been moved and seconded that Senate Bill 5031 be reported. Clerk, could you call the roll?
Senator Ruff. Senator Locke. Senator Vogel.
Aye.
Senator Eben. Senator Reeves.
Aye.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggins.
Aye.
Senator Barker.
Aye.
Ayes 14, no 0.
Ayes 14, no 0. The bill is reported. All right, and then the last bill we have is Senate Bill 5117 from Senator Deeds.
Thank you, Mr. Chair. This bill deals with the code section 44-146.17 that was the subject of a number of bills earlier. As Senator Newman pointed out, executive orders have the effect of law. That's down on lines 32 and 33 of the code of the bill. That's existing law. But right now, the only penalty for a violation of an executive order is a Class 1 misdemeanor. This bill would make them also subject to, or an alternative punishment would be a civil penalty of up to $500. It would direct the $500 penalty into the literary fund, which we have used for the construction of schools. That's what the bill does. And I think that's the bill that Senator Donovan was referring to. It would probably have a positive fiscal impact.
Right. All right, are there any questions of Senator Deeds?
Yes, Mr. Chairman, I have one.
Yes, Senator Donovan.
How will this be enforced? Who is going to give out the citations.
That part of it doesn't change, Senator Donovan. I would say, Mr. Chair, this will be, I guess, the civil penalty or the civil violation would go out on summons, which is down on page, or on line 36 and 37. The same people that enforce the law with the criminal penalty would also be in charge of enforcing the civil penalty.
Mr. Chairman, speak to the bill when appropriate.
Yeah, Senator Donovan.
Do you want me to, Mr. Chairman and Senator Deeds, I don't know how much you were in on the conversation about mask wearing and the mandate with the governor's office, but I have to tell you that it was a hardship. The Virginia Department of Health did not want to enforce any kind of repercussions or penalties, and the question was, would the police be getting involved in issuing those citations? Listen, here's the truth. For all the bumps we've had in this pandemic, Virginians have listened and they've responded. We used a carrot, we worked with them, guidelines were set, mandates were debated but generally followed. When there were problems with that, new kinds of incentives and directions were offered. We do not need to be offering civil penalties to our constituents from executive orders that have not gone through the General Assembly. You are going to create an enormous amount of acrimony without it being productive, and you're not only going to place hardship on Virginians, you're going to place hardship on the agencies. I am strongly against this bill, Mr. President, and I hope, Mr. President, oh my gosh, sorry guys, Mr. Chairman, and I hope that we will make the right decision for Virginians and PBI this today.
Mr. Chair, I guess if you want to be against the bill just because you want to be against the bill, that's a good reason. But a violation right now is a Class 1 misdemeanor. This simply sets up an alternative that doesn't result in a criminal conviction.
All right. Are there other questions or discussion on the bill? All right, is there a motion?
Mr. Chairman.
Yes.
Real quick, I'd just like to speak to the bill.
Certainly.
We talked about a lot of these before, and a lot of it's born out of our frustration of where we are. And I told a number of the patrons that, I think we ought to look at those discussions, but on the other side of this thing, as we look back and do a postmortem, I see what the gentleman's trying to do to try to give an alternative. Right. So the only option isn't criminal. But I am not going to support this bill as I didn't support the others, and that I want to put this in the group that we look back at and see how could we have done this better, and how should we adjust on a go forward well after this is in our rearview mirror. Thank you, Mr. Chairman.
All right. Is there other discussion? Senator Boysko.
Thank you, Mr. Chairman. I have a question for the patron.
Yes.
Thank you, Mr. Chairman. Senator Deeds, could you clarify, I think it says not more than $500 penalty. Does that mean in your mind that there could be a much lesser penalty?
It does, just like a Class 1 misdemeanor is not more than $2,500. This is about a fifth that, but it can be much less than that, yes. This is an administration bill.
Thank you.
Mr. Chair.
Yes, Senator Ashby.
Mr. Chair, I just have a question for the patron. Is it possible, and just for my own education, to get a warning for a misdemeanor, or is there no other option? You're going to get that misdemeanor charge or you're not?
Mr. Chairman, I would say that the officer always has discretion of whether he's going to issue a charge or not. It's just like when you're traveling down the road and you're going a little bit fast. Sometimes the officer will give you a warning, sometimes they won't. The officer always has that discretion, and I would assume that he would have the same with respect to a civil penalty.
All right, thank you, Senator Kiggins. Does anyone else have any questions or discussion? All right, is there a motion on the bill?
Move to report.
All right, we have a motion and a second to report.
Substitute motion, move to PBI.
All right, a motion to PBI. Is there a second to that motion? Second. All right, we have a motion and a second to PBI as a substitute motion. Is there any further discussion? All right, clerk, could you call the roll on the motion, substitute motion to pass by indefinitely?
Senator Ruff. Senator Locke. Senator Vogel.
Aye.
Senator Eben.
No.
Senator Reeves.
Aye.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko.
No.
Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
No.
Senator Kiggins.
Aye.
Senator Barker.
No.
7 ayes, 7 nays.
All right, is there any, we will go then back to the original motion, which was to pass by indefinitely. So we have that motion. Is there any discussion on that? All right.
Mr.
Clerk,
Chair, I
could you-
think the motion is to report the bill.
Oh, I mean to report it out. I'm sorry, I got it reversed. That was my mistake. So this is a motion to report the bill. Clerk, could you call the roll?
Senator Ruff. Senator Locke. Senator Vogel.
No.
Senator Eben. Senator Reeves.
No.
Senator McPike. Senator Donovan. Senator Mason. Senator Boysko. Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Aye.
Senator Kiggin.
No.
Senator Barker.
Aye.
7 ayes, 7 nays.
All right. Unless anybody has another motion, we've had two motions that both failed on a 7-7 vote. So it appears that we are split on this particular issue. And so there's no action that will occur, I guess, today on Senate Bill 5117. Is there anything further to come before the committee? All right, the committee then will rise, and thank you all for getting us through this session. So.